You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The liability landscape in privacy law can be divided into two broad categories: civil and criminal exposure. Civil liability arises when organizations or individuals are held accountable for privacy violations through lawsuits, regulatory enforcement, or administrative actions. These cases often focus on compensation for harm, compliance failures, or injunctive relief to prevent future misconduct. Criminal liability, by contrast, involves government prosecution for intentional, reckless, or egregious violations of privacy statutes. Criminal sanctions are rarer, but carry far greater consequences, including fines and imprisonment. For exam candidates, the critical point is to distinguish the thresholds. Civil cases often involve negligence or misrepresentation, while criminal cases typically require willful misconduct or fraudulent intent. Understanding this divide is key to analyzing enforcement frameworks, as it influences both the remedies available and the strategies organizations adopt to manage compliance risk. Contract liability is a common form of civil exposure in privacy matters. Organizations frequently enter into privacy promises through service agreements, data processing contracts, or privacy policies. When these commitments are breached, such as a vendor failing to implement agreed security safeguards, counterparties may sue for damages. Courts treat privacy promises in contracts as enforceable obligations, creating accountability even in areas without direct statutory mandates. For learners, the key term is enforceability. Once privacy terms are written into a contract, failure to uphold them creates legal exposure. Exam questions may test whether liability arises from statutory law, common law, or contractual obligations. Recognizing contract liability illustrates how private law instruments reinforce compliance alongside public regulation. Tort law provides another avenue for civil liability, particularly through negligence and privacy-specific torts. Negligence claims arise when organizations fail to take reasonable care in safeguarding personal data, leading to breaches or misuse. Traditional privacy torts include intrusion upon seclusion, public disclosure of private facts, and appropriation of likeness. These judicially created remedies allow individuals to recover for harms, even when statutes do not apply. For exam candidates, the key idea is that tort liability operates independently of statutory frameworks, providing a safety net in privacy enforcement. Scenarios may test whether described conduct fits within a tort theory, requiring learners to distinguish negligence from intentional intrusions. Tort law thus reinforces privacy protection through the broader civil justice system. Unfair and deceptive acts and practices liability exposes organizations to enforcement when they misrepresent data practices or fail to uphold stated commitments. Under federal and state UDAP statutes, regulators may pursue organizations whose privacy notices are misleading or whose security practices are inadequate despite assurances to consumers. For learners, the important terms are unfairness and deception, which carry specific legal definitions. Exam questions may test whether conduct qualifies as deceptive, such as promising not to share data while secretly selling it. Recognizing UDAP exposure is essential because it applies broadly across industries, allowing regulators to enforce privacy protections even in the absence of sector-specific statutes. Fiduciary duty concepts are increasingly applied to privacy, particularly in contexts where organizations act as stewards of sensitive data. Some scholars and regulators argue that companies holding personal information owe duties of loyalty, care, and oversight similar to those imposed on trustees or financial advisors. Breaches of fiduciary duty could arise from reckless data handling, inadequate security investments, or failure to disclose conflicts of interest in data use. For exam purposes, fiduciary duty signals a conceptual shift: privacy obligations framed as ethical responsibilities of trust rather than just compliance checklists. Scenarios may test whether this duty applies in given contexts. requiring learners to evaluate evolving interpretations of data stewardship. Standing, injury, and causation requirements shape whether private plaintiffs can bring civil claims. Federal courts require injury in fact, meaning plaintiffs must show concrete harm from a privacy violation. Courts vary in their willingness to recognize intangible harms, such as loss of control over data or heightened risk of identity theft. Causation links the defendant's actions to the harm, while redressability ensures the court can provide a remedy. For exam candidates, the key concept is standing as a gatekeeping requirement. Scenarios may test whether a plaintiff can bring suit under statutes like BPA or VPPA. Recognizing these requirements helps explain why some privacy claims succeed while others are dismissed at early stages. Remedies in privacy cases can include statutory damages, actual damages, punitive damages, and injunctive relief. Statutory damages provide fixed compensation regardless of harm, as in VPPA claims. Actual damages compensate for measurable losses, such as financial fraud. Punitive damages punish egregious misconduct, deterring future violations. Injunctive relief orders organizations to change practices, often forming the backbone of regulatory settlements. For exam purposes, learners should remember this taxonomy, as exam questions may test which remedy applies in different contexts. Understanding the range of remedies clarifies the stakes for organizations and illustrates how civil liability shapes compliance strategy. Class actions magnify privacy litigation risks by allowing groups of consumers to sue collectively. Certification hurdles include showing commonality and adequacy of representation, but when successful, class actions can lead to massive settlements. Privacy statutes with statutory damages such as BPA are particularly prone to class litigation. Settlement dynamics often involve monetary compensation, injunctive relief, and consumer remediation programs. For exam candidates, the key terms are certification and settlement. Scenarios may test whether a privacy claim can proceed as a class action, requiring analysis of procedural requirements. This highlights the significant role of collective litigation in shaping privacy enforcement outcomes. Arbitration clauses and class action waivers, often embedded in contracts, restrict litigation pathways. These provisions require disputes to be resolved individually in arbitration rather than through collective lawsuits. Courts often enforce these clauses, though they remain controversial. For learners, the important idea is that arbitration shifts disputes from public courts to private forums, altering remedies and reducing exposure. Exam questions may test whether such clauses are enforceable or whether statutory rights override them. Recognizing arbitration and waiver provisions ensures candidates can analyze litigation risks accurately, particularly in consumer privacy contexts where contracts govern data use. Statutes of limitations establish time limits for bringing privacy-related claims. These limits vary by statute and may depend on when harm occurred or when it was discovered. Accrual rules determine when the clock starts, whether at the time of the violation, discovery, or injury manifestation. For exam purposes, the key terms are limitations and accrual. Scenarios may test whether a claim is time-barred, requiring careful application of statutory rules. Understanding these limits ensures accurate analysis of litigation viability, reinforcing the procedural dimensions of privacy enforcement. Administrative enforcement processes add another layer of civil liability. Agencies such as the FTC or CPPA often resolve cases through consent orders rather than litigation. These orders impose compliance obligations, such as audits, risk assessments, and reporting. Monitoring and independent assessors may verify ongoing adherence. For exam candidates, recognizing administrative enforcement highlights that liability does not always involve courts but can arise through agency authority. Scenarios may test whether an agency action constitutes binding obligation or voluntary guidance, requiring precise analysis of enforcement mechanisms. Corporate governance duties extend liability to organizational leaders. Boards and audit committees must oversee data risk management, ensuring privacy and security are integrated into governance. Failure to do so can result in derivative lawsuits or regulatory scrutiny. For learners, the key idea is oversight. Privacy is a board-level responsibility, not merely an IT issue. In extreme cases, individual officers or employees may face liability for reckless or fraudulent conduct, particularly if they knowingly mislead regulators or conceal breaches. On the exam, scenarios may test whether liability applies to the corporation, leadership, or individuals. This underscores that privacy governance is both organizational and personal. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. The Federal Trade Commission remains the central federal regulator for privacy enforcement, and its remedies framework reflects both flexibility and rigor. When the FTC identifies violations under Section 5 of the FTC Act or through statutes like COPPA, it often imposes consent orders requiring organizations to overhaul their privacy and security programs. These orders can last up to 20 years and may require regular risk assessments, independent audits, and reporting obligations. While civil penalties are not always available under Section 5, they become available under statutes with penalty provisions. For exam purposes, the key idea is long-term compliance. FTC actions often reshape industry norms by signaling what counts as reasonable security or fair practices. Learners should recognize that FTC remedies go beyond punishment. They establish compliance obligations that ripple across markets. The Department of Health and Human Services plays a parallel role in the health sector through enforcement of HIPAA. Its Office for Civil Rights can impose civil monetary penalties for violations of the privacy, security, or breach notification rules. Penalties are tiered based on the level of culpability, ranging from lack of knowledge to willful neglect. Corrective action plans often accompany fines, requiring organizations to implement specific safeguards under regulator supervision. For candidates, the key terms are civil monetary penalties and corrective action plans. Exam scenarios may test whether enforcement stems from HHS rather than the FTC, underscoring the sectoral nature of privacy law. This framework illustrates how healthcare organizations face unique enforcement challenges, blending monetary liability with mandated structural reform. The Consumer Financial Protection Bureau oversees financial privacy under statutes such as the Fair Credit Reporting Act. The CFPB's tools include supervisory examinations and enforcement actions, which may result in penalties, remediation, or restrictions on business practices. Unlike the FTC, the CFPB has direct supervisory authority over financial institutions, enabling proactive oversight rather than reactive enforcement. For exam purposes, candidates should note the distinction between supervision and enforcement. Scenarios may describe examinations uncovering violations, leading to penalties or required reforms. Recognizing the CFPB's authority reinforces the point that privacy governance differs by sector, with financial institutions facing both compliance duties and continuous oversight from a dedicated regulator. The Federal Communications Commission enforces privacy obligations in telecommunications and marketing contexts. It oversees robocall rules, consent standards under the TCPA, and privacy of customer proprietary network information. FCC enforcement often involves administrative processes that escalate from notices to forfeiture orders imposing significant fines. For exam candidates, the key concept is statutory damages, particularly under the TCPA, where violations can yield large financial exposure. Scenarios may test whether liability arises under FCC authority rather than FTC or CFPB, requiring careful mapping of obligations to the correct regulator. The FCC's role highlights how privacy enforcement intersects with communications infrastructure and consumer marketing protections. State attorneys general amplify enforcement through multi-state actions and stipulated judgments. When large-scale breaches or widespread consumer harms occur, multiple states coordinate to impose financial penalties, injunctive relief, and compliance monitoring. These settlements often have national impact, forcing organizations to adopt reforms across all jurisdictions. For exam purposes, the key terms are multi-state action and stipulated judgment. Scenarios may test whether state enforcement operates independently or alongside federal agencies. Understanding this dynamic shows how state oversight creates additional liability risks, reinforcing the patchwork enforcement model of U.S. privacy law. The California Privacy Protection Agency adds a dedicated state-level regulator to this landscape. The CPPA conducts audits, issues regulations, and enforces compliance under the CCPA and CPRA. Its administrative enforcement powers include fines and corrective orders, complementing the Attorney General's authority. For candidates, recognizing CPPA authority is critical because it represents an emerging model of specialized privacy regulation at the state level. Exam questions may test whether enforcement authority lies with the CPPA or the Attorney General, requiring learners to understand the evolving distribution of state power in privacy oversight. Private rights of action significantly increase litigation risk. Illinois' Biometric Information Privacy Act allows individuals to sue directly for violations, leading to large class actions and settlements. For exam purposes, the key terms are biometric litigation and private right. Scenarios may test whether statutory design permits individual suits or limits enforcement to regulators. Recognizing the litigation potential under laws like BIPA is essential for analyzing risk exposure, as statutory damages and class actions magnify liability beyond regulatory penalties. The Video Privacy Protection Act provides another example of private enforcement, granting consumers the right to sue over disclosure of viewing histories or streaming data. While initially aimed at videotape rental records, VPPA has been applied to digital platforms, creating unexpected liability for organizations handling streaming information. For candidates, the key term is statutory damages, as VPPA provides monetary remedies without proof of actual harm. Exam questions may test whether disclosure of streaming data falls within VPPA's scope, requiring careful application of statutory language to modern contexts. Telemarketing liability illustrates how statutory damages escalate risk. The TCPA allows private suits for unlawful calls and texts, with damages often calculated per violation. This structure creates enormous exposure in class actions, where thousands of violations can aggregate into multi-million-dollar liability. For exam purposes, the key terms are consent standards and statutory damages. Scenarios may test whether proper consent was obtained for marketing communications. Recognizing TCPA liability emphasizes how consumer protection statutes create potent enforcement mechanisms beyond regulatory oversight. Data breach notification statutes add yet another layer of liability. States impose deadlines and content requirements for breach notifications, and failure to comply can trigger penalties from attorneys general or private rights of action in some jurisdictions. For learners, the key terms are notification timelines and layered penalties. Exam scenarios may test whether organizations met state requirements or whether delays create liability. This area highlights how state statutes extend liability beyond breaches themselves to organizational transparency and responsiveness. Self-regulatory programs can impose their own enforcement consequences. Organizations participating in frameworks like the Network Advertising Initiative or PCI-DSS may face suspensions, public notices, or expulsion for violations. These consequences can damage reputation and business relationships, even without statutory liability. For exam purposes, candidates should recognize that liability is not only legal, but also reputational and contractual. Scenarios may test whether enforcement arises from statute, regulator, or self-regulation, requiring precise classification of consequences. Cross-border coordination introduces another dimension of enforcement. U.S. regulators increasingly cooperate with international counterparts through networks like GPEN. This means that violations may trigger investigations in multiple jurisdictions, amplifying liability and complexity. For candidates, the key concept is international cooperation. Exam scenarios may test whether regulators coordinate across borders, requiring recognition of global enforcement dynamics. This reflects the reality that privacy violations rarely remain confined within national borders. Post-incident remediation plans form part of many enforcement outcomes. Regulators may require organizations to submit detailed corrective action plans, set milestones, and report progress. Verification reporting, sometimes by independent assessors, ensures compliance is sustained over time. For exam candidates, the key terms are remediation and verification. Scenarios may test whether organizations fulfilled post-incident obligations, reinforcing the principle that enforcement extends beyond initial penalties into ongoing reform. Integrating risk assessments into compliance programs reduces recurrence and demonstrates diligence to regulators. By conducting regular privacy and security risk assessments, organizations can identify vulnerabilities and implement safeguards proactively. For learners, the key idea is risk integration. Enforcement frameworks often treat proactive assessment as evidence of good faith. On the exam, scenarios may test whether risk assessments were performed and documented. Recognizing the role of assessments highlights how compliance by design strategies reduce liability while building resilience against future incidents. By synthesizing civil and criminal liability, remedies, and enforcement processes, candidates gain a comprehensive view of the privacy enforcement framework. Civil liability dominates the landscape, with regulatory actions, private lawsuits, and contractual obligations creating overlapping risks. Criminal liability remains limited to egregious cases but carries severe consequences. Together, these frameworks emphasize that compliance must be proactive, comprehensive, and documented. For exam preparation, the takeaway is clear. Success depends on distinguishing liability types, recognizing remedies, and adopting compliance by design strategies that anticipate and mitigate risk across jurisdictions. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.